A mother and her son were deeded a farm. When the mother willed her interest to her other child, the son went to court and learned that showing the intended form of ownership was a hard row to hoe in re estate of Michael. Joyce King gave her farm to Harry, Bertha, Ford, and Helen. The deed outlined the ownership as, quote, Harry L. Michael and Bertha M. Michael, his wife, tenants by the entireties, and Ford W. Michael and Helen M. Michael, his wife, as tenants by the entireties with right of survivorship, unquote. The deed talked about the rights of these four and their heirs. Harry died. Bertha executed a will that split her estate evenly between her two sons, Ford, who had an interest in the farm, and Robert. Bertha willed Robert her interest in the farm. When Bertha died, Robert and Ford tried to settle Bertha's estate, but disagreed about whether Bertha owned an interest in the farm. Robert and Ford needed a court to resolve this disagreement. Robert argued that the deed meant that the two couples owned a half interest in the farm as tenants in common. Further, references to tenancy by entirety only applied to how the couples owned their halves. As a result, the tenancy in common didn't give Ford any rights of survivorship. So, when Bertha died, her half went to her estate for Robert to inherit. Ford argued that the phrase right of survivorship in the deed meant that Ford automatically received Bertha's half of the farm on her death. The court agreed, reasoning that the right of survivorship appeared once, after both sets of couples were listed. Robert appealed.